And finally, the appearances for the victims, please.
Good afternoon, Madam President, Your Honours. Good afternoon to everyone in and around the courtroom. The participating victims are represented by Militia Beaulieu-Bussier, next to me, from the Quebec Bar.
And finally, the appearances for the victims, please.
Good afternoon, Madam President, Your Honours. Good afternoon to everyone in and around the courtroom. The participating victims are represented by Militia Beaulieu-Bussier, next to me, from the Quebec Bar. Saif Kassis, our case manager, and most importantly, Imran and Umda, our field assistants, who are out there watching in big rooms with our clients, the participating victims. Thank you. Oh, and myself, Nathalie von Westinghausen.
Yes, thank you very much, Ms. von Westinghausen. Yes, we are here today to deliver a summary of the judgment in this case. The case relates to crimes against humanity and war crimes which took place between August 2003 and March 2004 in Darfur, Sudan. The Sudan situation was referred to the International Criminal Court by the UN Security Council by its resolution 1593 on the 31st of March 2005. Whilst, as is well known, arrest warrants were issued for other leading actors in that conflict in Darfur, none have been executed, so that the trial of this accused, who surrendered himself in 2020, is the only one which has taken place. The evidence given by the many innocent civilians, mainly from the Fur tribe, who were victims of the grave and undisputed crimes, has revealed the suffering they underwent at the time, which still continues today. This trial has for the first time allowed them a voice with which to inform the world of what has happened to them as a result of this conflict. Moreover, it should not be forgotten that since April of 2023, another as yet unresolved and underreported armed conflict has visited yet further misery upon the innocent citizens of Sudan. What follows is a summary of the full judgment, intended to convey the main findings made therein for the benefit of the accused and for the public. The judgment contains the Chamber's analysis of the evidence and its detailed reasoning, and is the only authoritative document. I turn now to the background. During the time relevant to the charges, a non-international armed conflict took place between the government of Sudan, using primarily a semi-regular force, the Janjaweed, on the one side, and the Sudanese Liberation Movement or Army and the Justice and Equality Movement on the others. Jointly, I'm going to refer to them as the rebels from here on in. Whilst the causes of the conflict went back many years, the catalyst for the outbreak of concerted violence was an attack on the El Fasher airport by the rebels on the 25th of April 2003. This led the government of Sudan to decide to quash the rebellion by force. In December 2003, the government of Sudan issued an emergency plan designed to achieve that objective and further to impose control over areas inhabited by or belonging to perceived rebellious non-Arab tribes, which included the Fur, the Mazalit, and the Zaghawa. I should pause for a moment. I apologize in advance for any mispronunciation of some of the names in this case. The emergency plan was encapsulated in a high-level, top-secret document. The political strategy elaborated therein by the National Security Council was based on the understanding that the non-Arab tribes, in particular the Fur, the Zaghawa and the Masalit, were leading the rebellion in Darfur. And the objectives of the plan were to restore security in the states of Darfur and end the rebellion through military and security decisiveness, to fight the rebels, and to impose control over all the villages and regions to which rebel leaders belong, and also the areas inhabited by the rebellious tribes. The emergency plan stated that this aim was to be achieved through the creation of these semi-regular forces from Arab tribes, which were to be provided with training and arms, assigned to a commander, and be assisted by the Sudanese armed forces with, and I quote, fire support and air assets during military operations. In addition, the plan stated that one of the purposes of creating these semi-regular forces from the Arab tribes was to, and again I quote, assassinate sympathizers from amongst community leaders, the umdas, and local administration officials. This semi-regular force was known as the Janjaweed, although it was also referred to by other names such as the Fursan, Arab militias, Bashmerga, or Mujahideen. Other semi-regular forces included the Popular Defense Forces, the PDF, the Central Reserve Forces, the CRF, and the Popular Police Forces, the PPF. The Chamber finds that it was this emergency plan which provided the blueprint for the commission of the crimes which then took place. Acting on Government of Sudan instructions, the Janjaweed carried out armed operations against several predominantly Fur and non-Arab villages in Darfur. Some of these operations were carried out jointly with the GOS forces, and during these operations, villages were pillaged and destroyed, civilians were murdered, raped, persecuted, mistreated, and forcibly displaced. Whilst many more villages were targeted, the operations charged in this case concern Kudum, Bindizi, Mukja, and Dalej. Particularly in Mukja and Dalej, 4 men of all ages who had fled with their families to Mukja and Dalej from the ravaged villages were detained, tortured, and subsequently taken to areas outside the towns where they were executed by members of the Janjaweed together with Government of Sudan forces. I turn next to the accused. The accused, Ali Muhammad Ali Abd al-Rahman, was born in Rahat al-Berdi at South Darfur in 1949. He belongs to the Taisha tribe, which is generally considered to be an Arab tribe in Sudan. A major issue in the case was whether during the charged period the accused was the man known by the nickname Ali Kushaib, and as such was the leader of the Janjaweed forces. The accused is a former member of the Medical Corps of the Sudanese Armed Forces, from which he retired in the early to mid-90s, A certificate from the Council of Medical Assistants and Technical Professions of Sudan states that Ali Muhammad Ali qualified as a medical assistant in 1984. And the highest rank held by the accused while in the Sudanese armed forces was that of a Musaid, in other words, a warrant officer. Upon his retirement from the Sudanese armed forces, the accused lived for the main part in Garsila, a town located in the Wadi Saleh area of West Darfur, and he opened a shop in Garsila market from which he sold medication. And what clearly emerged from the evidence in this case is that the accused was a person of some renown, highly respected in the Wadi Saleh area even before the conflict. Sometime in 2004, after the events of this case, he became a member of the Central Reserve Forces, the CRF, in which organization it appears he remained until shortly before his surrender to this court on the 9th of June 2020. That surrender came about as a result of arrest warrants being issued by the pretrial chambers as long ago, first of all, as 2007, and then again in 2018. The arrest warrants were issued in his legal name, but also with the nickname Ali Kushaib. And so let me turn to that name, Ali Kushaib. During the course of communications with the prosecution for his surrender, the accused made a video recording in which he clearly and unequivocally stated, "I am Ali Muhammad Ali Abd al-Rahman, and my nickname is Kushaib." However, from the time of his arrival at this court, he denied that he was in fact Ali Kushaib. Accordingly, the chamber heard from a number of witnesses who had known the accused well, either as friends, army colleagues, or because they were with him during the period of the charged events. The chamber also heard from witnesses who had been to his pharmacy in Garsila and subsequently recognized him as both present and taking part in the commission of the crimes charged. The witnesses whom the chamber found to be the most persuasive were those who knew the full name of Ali Kushaib to be Ali Muhammad Ali Abd al-Rahman, or a variant thereof. Further, that they had a credible and reliable basis for their knowledge of his name and nickname, and gave evidence of interacting with and or seeing or being in the presence of Ali Kushaib during the charged period. It is right to point out that a number of witnesses called by the defense who had known the accused in Rahat al-Badi stated that they did not know him by that nickname, nor had ever heard it applied to him. The chamber was unpersuaded by the evidence of the witnesses called by the defense and is satisfied that the accused was the person known before and during the period of the charges as Ali Kushaib. I turn now to list the charges. The accused stood trial on 31 charges divided into the areas in which the crimes occurred, namely, first, Kudum and Bindizi. Count 1, intentionally directing attacks against the civilian population as a war crime. Count 2, murder as a crime against humanity. Count 3, murder as a war crime. Count 4, pillaging as a war crime. Count 5, destruction of the property of an adversary without military necessity as a war crime. Count 6, other inhumane acts as a crime against humanity. Count 7, outrages upon personal dignity as a war crime. Count 8, rape as a crime against humanity. Count 9, rape as a war crime. Count 10, forcible transfer as a crime against humanity. Count 11, persecution as a crime against humanity on political and ethnic grounds. Thank you. Mukjar. Count 12, torture as a crime against humanity. Count 13, torture as a war crime. Count 14, other inhumane acts as a crime against humanity. Count 15, cruel treatment as a war crime. Count 16, outrages upon personal dignity as a war crime. Count 17, murder as a crime against humanity. Count 18, murder as a war crime. Count 19, attempt murder as a crime against humanity. Count 20, attempt murder as a war crime. Count 21, persecution as a crime against humanity on political, ethnic and gender grounds. As far as the leisure is concerned, count 22, torture as a crime against humanity. Count 23, torture as a war crime. Count 24, other inhumane acts as a crime against humanity. Count 25, cruel treatment as a war crime. Count 26, outrages upon personal dignity as a war crime. Count 27, murder as a crime against humanity. Count 28, murder as a war crime. Count 29, attempt murder as a crime against humanity. Count 30, attempt murder as a war crime. And count 31, persecution as a crime against humanity on political, ethnic and gender grounds. Next, I turn to the formation and arming of the Janjaweed. The Chamber finds that the mobilization and arming of the Arab tribes started after a meeting in September 2002. This meeting, which gathered members of all Arab tribes in Darfur, was prompted by security violations and tribal conflicts, and had among its objectives to eradicate tensions, malpractices, and direct or indirect causes of security issues. However, it was after the promulgation of the emergency plan that the government of Sudan, exploiting existing tribal tensions, used the Janjaweed to assist them in countering the rebels. In the early stages of the conflict, the Janjaweed used camels, horses, and donkeys as their mode of transport, but the government of Sudan later provided them with more military equipment and vehicles, such as land cruisers and trucks mounted with a gun, known as a DSK, on the back. During the period of the charges, the Janjaweed received funding, training, such as it was, and weapons from the government of Sudan. Numerous witnesses spoke of weapons distribution taking place in the Wadi Salah area during and after 2003. Weapons and other military material were distributed on government premises, including on the Sudanese Armed Forces premises, the CRF and the PDF bases. Although in 2003 these were largely distributed by a man called Lieutenant Hamdi, the head of intelligence in Mukjar, the accused was also involved. On at least one occasion, shortly before the Kudum Bindizi operation, Minister Haroun, then State Minister for the Ministry of the Interior, together with other senior army commanders, arrived at Mukjar in a helicopter and delivered weapons and funds for the Janjaweed. Members of the Fur tribe were denied the weapons as they were on each weapons distribution. According to at least one witness, the reason for the government of Sudan using the Janjaweed was that they were not constrained by any of the rules and regulations which applied to the regular government of Sudan forces. Next, the question of state policy. The Chamber is satisfied that the attack against the civilian population, mounted by the government of Sudan forces and other semi-regular forces, including the Janjaweed, was part of a plan designed at the highest level of state and encapsulated, as already mentioned, in the emergency plan adopted on the 18th of December 2003. That plan does show that the conflict had an ethnic dimension. Entire communities of the Fur, Saghawa and Masalit tribes were to be targeted and attacked because their members were all perceived as associated with the rebels and thus as the enemy. And as already stated, the emergency plan specifically stated that the project included the assassination of sympathizers from amongst community leaders and local administration officials. Such orders made no distinction between fighters and civilians, who all seemed to be the target of the planned military operations. And there can be no doubt that the execution of that plan would involve the commission of crimes. Moreover, the commencement of each of the criminal operations was preceded by a visit to the relevant area from high-ranking government of Sudan officials. The evidence of the crimes shows that they came about within two distinct but linked phases. The first, which culminated in the attacks on Kudum and Bendizi, took place in August 2003. The second, involving the towns of Mukjar and Dalej, took place in February-March 2004. I start with Kudum and Bendizi. In early August 2003, the rebels mounted limited, in the sense of few casualties were caused by these attacks, limited attacks on Bendizi and then Mukjar. One of the results of those attacks was that the police stationed in Kudum and Bendizi withdrew to Mukjar. A few days later, the accused arrived in Mukjar with a large contingent of the Janjaweed. On or around the 9th of August 2003, a government of Sudan delegation arrived in Mukjar, comprised of Minister Haroun and other high-ranking officials. After a closed meeting attended by the accused, these officials held a public meeting, attended largely by members of the Janjaweed, but also present were local citizens from the Fur ethnic group. The accused, standing near the minister, addressed the crowd, saying that he spoke, and I quote, on behalf of the Janjaweed, and further, the Janjaweed were there to defend the property of the government, and that they were alongside the armed forces. The minister told the crowd to, as he put it, wipe out and sweep away, the words in Arabic being amsa aksa, which are words that figured very strongly through this case. And the Fur do not keep anybody alive, and said that the Fur and their money were war booty or a prize for the Janjaweed. P903, a witness who was present at the time and who was a member of the Fur tribe, interpreted Haroun's statements as dangerous and stated that he felt afraid and immediately left the place. During this gathering, a Fur sheikh in the crowd urged the minister to stop the Janjaweed from looting the houses and properties of the inhabitants of Mukjar. P878, who was also present, recalled the minister replying that the people of Mukja must return the property of the state that has been looted by their, as he said, their children, meaning, in fact, the rebels, and that if they did not return the property, you will be looted, you will be killed, you will be raped. After this speech, a joint Janjaweed Government of Sudan Forces operation took place in villages to the north and east of Mukja, which were then burnt. On the 15th of August 2003, a large, heavily armed contingent, estimated to be over 1,000 men, of the Janjaweed, led by the accused, and accompanied by a few vehicles containing CRF personnel, set off towards Kudum and Bindizi, which were administrative regions situated in the Wadi Sala area. Their route took them via the villages of Naeli, Tiro, Merli, Drangal, and Seda. Kudum and Bindizi and the other villages all had predominantly Fur populations, and none had any kind of rebel presence. In August 2003, approximately 1,600 families were residing in Kudum and approximately 1,800 in Bindizi. In both places, only some men possessed basic weapons to protect their cattle. Over the following 2 days, the Janjaweed swept through all these inhabited places. Whilst only the attacks on Kudum and Bindizi are charged in the present case, the attacks on all the places took the same form. The accused, when ordering the Janjaweed to commence the attacks, accompanied those orders using chants like Alu Akbar and Amsa Aksa. The Janjaweed fired at and chased away the inhabitants, looted properties, taking livestock and household goods before burning down houses. A vivid description was provided by P12. He said, and I quote, "There was a lot of fire. 90% of the homes in Bindizi are constructed using local materials. They are wooden materials, flammable, so the entire town was in fire. It was a terrifying situation. Smoke was coming up everywhere. It's beyond words to describe this. After the attack, it was a rubble of ashes, corpses scattered everywhere. It's the destruction that results from war. All that was left in Bindizi were smithereens and ashes. During the attack, there were senior people and children, and it's difficult for such people to leave. Someone who's 90 years old during the attack is not in a position to flee. So when war happens, you can imagine what that person's fate is. This is what I saw with my own eyes in Bindizi."